I'm joined again by Stephen Palley, partner at the law firm of Anderson Kill. Stephen, thanks so much for coming back to the show.
My pleasure to be here. Always good to be with you.
Great. So today you're going to help us kind of do a bit of a deep dive into BitMEX versus the CFTC.
Sure.
As most people within the crypto industry will probably already be aware, the Department of Justice recently filed an indictment against the senior executive team at BitMEX, charging that they have been in violation of the US Bank Secrecy Act. And simultaneously, the CFTC also took civil enforcement action against BitMEX, claiming that it had subsidiaries and affiliates in the US and knowingly onboarded US customers or failed to do enough to prevent US customers from onboarding.
That's right.
Okay, so it sounds like in the CFTC's eyes, BitMEX was operating as what it classified as a futures commission merchant, which is a role that falls under the Bank Secrecy Act and the Commodities Exchange Act, which would have required them to register with the CFTC.
That's right.
Okay, so it sounds like the executives that are named are their CEO, Arthur Hayes, their COO, Ben Delo, their CTO, Samuel Reed, and Greg Dwyer, who was their head of business development. And Reed was detained by law enforcement in the US, but was subsequently released on bond. So lots to talk about. So let's start with, can you summarize the course of events and what exactly happened?
Sure.
What the executives are being charged with, and what are the two separate, what's the delineation between the civil proceedings and the criminal?
Sure. Well, let's start with sort of big picture, particularly for those who aren't in the U.S. and don't understand how U.S. laws work. You've got two different things that have happened. One is the Commodities Futures Trading Commission is a U.S. agency responsible for commodities futures trading broadly, and enforcing and regulating things that are covered by the U.S. Commodities Exchange Act, which generally speaking, and I'm summarizing, deals with derivatives, futures, things of that nature. And so, and there's some enforcement jurisdiction over spot markets, but only when the spot market trading involves fraud and manipulation that might impact futures markets. So that's the CFTC. And what they can do is, if they see something that appears to have violated the laws that they're charged with enforcing, they can undertake a formal investigation, which is something that doesn't involve a court filing. It might involve, probably would involve a subpoena, document requests, formal interviews under oath, depositions, and then they make a decision whether or not they're going to pursue litigation in court if they can't resolve charges privately. And it appears that what happened here was that the CFTC commenced an investigation of HDR Global Trading, a bunch of companies that we can refer to, generally speaking, as BitMEX, and included in their investigation Arthur Hayes, Ben Delo, and Samuel Reed. And I'm going to take a look at the summary in the lawsuit that was filed, and the CFTC says that BitMEX is, says that it's one of the largest crypto derivatives platforms in the world with billions of dollars of trading each day. And the problem is, from the CFTC's perspective, is that a lot of this derives from access to the United States and to U.S. customers. And they mention, I want to say, 85,000 customers or customer contacts within the United States. And they're trading things that fit within the rubric of, they were offering leveraged retail commodity transactions, futures, options, and swaps, and operating as an unregistered futures commissions merchant. All of these things which required registration with the CFTC, and that is violates doing that without complying with CFTC regulations, without registering as required by the Commodities Exchange Act, which sounds really boring, I realize, subjects you to substantial penalties under U.S. law. And so that's sort of the nature of the CFTC civil complaint. We can dig more into that. There's another piece of this, which is I actually don't find it terribly surprising. I know others in the space might have, but in parallel with these civil proceedings, the United States Department of Justice, which is also part of the executive branch in the United States, instituted criminal charges, an indictment, which is a way that you charge people criminally in the United States, against the executive team of BitMEX, charging that they had violated the U.S. Bank Secrecy Act and anti-money laundering, know your customer requirements, and all sorts of compliance obligations that go with that. And as you, I think, pointed out, the CTO, Samuel Reed, was arrested. He was, I believe he was released. All that we can see from the docket was that he appeared before a federal judge on October 1st or 2nd, and the next day documents setting conditions of release were issued that imposed fairly reasonable limitations for someone charged with such serious crimes, a $5 million bond with the requirement of $500,000 in collateral being posted, but no restrictions to staying at home, the ability to move between Massachusetts, New York, and Wisconsin, no requirement that any sort of monitoring be worn, which leads one to suspect, and again, this is pure surmise, I have no, if I had inside information about this, we wouldn't be talking, right? But does lead one to suspect that maybe he is, he's worked out a deal. The last time I checked, and I will confess I didn't check today, I'll check in a second. As far as I know, the other defendants remain at large. Let's check right now, shall we? So that's basically the that's the nuts and bolts of it.
So, you know, in traditional finance and certainly in other cases that we've seen in the crypto space, having a regulator assess, you know, fines or penalties in a civil proceeding is one thing. It's not often that we see, you know, people arrested and criminal charges brought. So how serious is this, Stephen?
I mean, it's as serious as a heart attack. It's the allegations are of significant and ongoing violations of the Bank Secrecy Act, a statute that has criminal penalties of up to 5 years imprisonment for each violation. I don't see any appearance by Mr. Hayes or Mr. Delo or Mr. Dwyer in the criminal case. It would appear that they are still at large. You know, they cite significant detail about the violations. Basically, the Bank Secrecy Act is designed, it comes out of, it refers to a set of laws that were first passed and put into law in the early 1970s as a response to organized crime, right? And I'm like, I'm oversimplifying greatly, but they're designed to, in the case of crypto in particular, to, upon amendment by the Patriot Act to, I'm quoting from the indictment, prevent, detect, and prosecute international money laundering and the financing of terrorism, which is something that the United States government takes very, very seriously. And there was a parallel statement issued by Treasury either on October 1st or September, the last day of September, it was the 30th or 31st, I don't remember, that we'll talk about in a little bit that kind of dovetails with this. Basically, if you are someone who was required under US law to comply with the Bank Secrecy Act and you don't, particularly if there's a view that you are directly or indirectly participating in you know, international terrorism, drug trafficking, the Department of Treasury, you know, the United States government, through FinCEN and through the DOJ, they're going to come after you hard. And that's what they did here.
Do you have perhaps a real world example of a similar case or scenario, maybe outside the crypto world, that resolved and what the outcomes of those would be? So essentially we're at the beginning of this. what potentially could we expect to see happen? What's happened to others in the past?
My expectation is there have been some crypto cases that involve this. My expectation is based on, drawing from other examples, and particularly given the fact that this has been going on according to the indictment since 2014, and from at least 2017 or 18, BitMEX knew that they were dealing with U.S. persons and that they were required to comply with the BSA, and they didn't. They moved to the Seychelles for the stated reasons that it would be easier to bribe people there. My expectation is that, so like my back of the envelope guess is that eventually the executive team will be extradited to the United States and will do prison time. There's been a significant flight of capital from BitMEX. I think they're down 30%. Certainly no interest in causing panic, and I don't have crypto holdings, so this doesn't affect me personally. I would be surprised if that exchange exists in a year or two. Like, why would you put your crypto at risk in an exchange that is subject to where the principals are being prosecuted by U.S. prosecutors, and where the CFTC has come down against them and is seeking disgorgement of profits, is seeking all sorts of monetary penalties? It doesn't make any sense to me. So short answer is prison.
Okay, so that's the maximum. That's the maximum penalty, imprisonment, and you're talking about 5 years for every violation. Is every violation down to a transaction or down to a customer? How do they determine how many violations
per transaction?
Per transaction. Okay.
Right, and I think I saw the number 85,000 somewhere. I think it was in the CFTC complaint. So if you credit that, here, let's see if I can find it. 85. There we go. Yes. So according to the CFTC, during the relevant period, BitMEX conducted trillions of dollars in digital asset derivatives transactions, notional, of course, and it earned fees worth more than $1 billion in transactions on its platform. BitMEX, operated its trading platform in large part from the United States and engaged in transactions with thousands of U.S. persons. BitMEX accepted Bitcoin deposits worth more than $11 billion from at least 85,000 user accounts with a U.S. nexus. So in theory, each of those, let's just use 85,000 and assume there was just one transaction to each account. In theory, you're looking at 500,000 years of prison time. Obviously, it doesn't work like that. My guess is 5 to 10, which gives the CTO a significant reason to cut a deal. And what's interesting, too, is because there was a civil investigation by the CFTC, it appears from looking at the documents, the CFTC got a significant amount of information from BitMEX, internal emails, interviews, and I'm sure they just turned that over to the DOJ.
Yeah.
So we saw the same thing. It's different because with Telegram and Kik, there were no criminal charges. Those are registration cases, nothing to do with BSA or AML KYC. But in those cases too, when the SEC filed suit, they already had a significant volume of information.
Well,
they had received from the target.
Something like BitMEX and all of the legal activity that's been they've been going through over the past couple of years.
It sure seems similar, doesn't it?
Yeah, well, I think what some in the market may say that BitMEX was headed in this direction, and that potentially leaning on the fact that they were only taking deposits and paying out crypto to crypto, that potentially it was beyond the scope of AML requirements.
That hasn't been the case since at least. The regulatory guidance has been fairly clear on this for the last 7 or 8 years. FinCEN has been pretty clear. that the fact that you are trading crypto for crypto does not take you out of the scope
Yeah.
of the Bank Secrecy Act. It hasn't been a good argument for a very long time.
Yeah. So, is this, in your opinion, just simply a case of hubris,
Yes.
or does BitMEX have a case to defend here?
Well, look, I mean, there's always a defense, um, but what was the line about coconuts? You know what I'm talking about?
Yes, I do.
I mean, the guy, like, these people,
The Seychelles were a more friendly jurisdiction for BitMEX because it costs less to bribe the Seychelles authorities just
yeah,
a coconut.
yeah, they don't cost to bribe regulators in the United States and elsewhere.
Yeah.
There was the Lambos at Consensus 2 years ago. I believe they had U.S. offices at various points. There was an email where they said we need to give this guy access because even though he's in the U.S., he's a whale. I think there was I'm looking at, so before I was a lawyer, I was getting a PhD in literature. So I look at things from the standpoint of narrative, right? Like the narrative here, if you will, is people got really rich in a very fortuitous, and let's accept that it was smart. It was like a good bet, but they got something not exactly from nothing. I won't say that. It required patience and in some instances significant technical understanding and, maybe mining, but they managed to make just absolutely a crazy amount of money in an unbelievable way. And I think that made some people think that they could fly really close to the sun, right?
So last week, the FCA actually issued a new regulation banning the sale, marketing, and distribution of crypto derivatives to retail customers. It was a pretty bold move. And, looking at this derivatives action being taken, is it the derivatives themselves that are causing regulators worry, or is it really the AML KYC thing, or is it a combination of the both?
It's both. Yeah. So basically, BitMEX got in trouble, and its principals got in trouble for both. They were selling certain types of derivatives to U.S. persons without being properly registered.
Yeah.
And at the same time, because they were an FCM, they had to register as a money servicing business with FinCEN and do things like file SARs, have a compliance program. So that led to criminal problems. It's not like, and I would say this, I don't think, it's not that the regulators have a problem with crypto, qua crypto. It's just that, if you're going to sell certain types of commodity contracts in the United States, we have laws that apply. And
Yeah.
if you're gonna engage in certain types of financial transactions and act as a money transmitter, and the definition of that is pretty clear under the U.S. law, and FinCEN has been clear about its role and the application of the statute to those activities since I think at least 2013, if not earlier. You have to comply, and you don't get a pass because it's Bitcoin. You just don't.
Yeah. Well, you referenced earlier that there was capital flight from BitMEX.
Yeah.
And then looking at things like the FCA ban, which many people have argued that if you aren't able to license firms to distribute these types of instruments to retail investors, they will go elsewhere to find them. And so, that capital that took flight from BitMEX is going to end up somewhere else. Should the executives of those offshore derivatives exchanges be worried? And is this the type of activity that we can expect to see continue, or is this BitMEX being kind of made an example of?
I don't know about, maybe they're being made an example of. I guess I would say it's a good time to get your house in order if you're offshore and maybe you've had contact with the United States in the past, and not for malevolent reasons, just because maybe you were sloppy. It's a good time to evaluate that and come up with a compliance plan, whether it's backwards looking or forwards looking. And in some cases, it's better to go to the regulator before they come to you.
Mm-hmm.
And I think maybe, I don't know how BitMEX handled that, but apparently however they handled it was not the right way. Otherwise it wouldn't be criminal charges. But it's, there are ways to work these things out. And that's the answer. And, the other answer is don't sell certain things into the US. Like I mentioned, contracts for difference. Generally speaking, unless you're dealing with someone who, people who fit into the rubric of an eligible contract party, if you're selling these things to regular old consumers, and you're selling into the US, and eventually there's a good chance, particularly if you scale and people notice, you can get in trouble. So that's not a normative statement. That's just the simple country lawyer pointing out what I think is the obvious.
Stephen Palley, you are anything but a simple country lawyer,
But
you are a dear friend, and thank you so much for joining me today and breaking this down for us. It's been a pleasure to see you.
Always a pleasure. Thank you.
Brilliant.